by the Civil Rights Section, headed by Clem McGowan, and responsibility filtered down to the Civil Rights Unit, headed by Edward McDonough. Richard Long, a headquarters case agent, was assigned to the investigation. As the case progressed, information on developments was passed up through the chain of command to Assistant Director DeLoach, Associate Director Clyde Tolson, and ultimately to Director Hoover. Major developments were summarized and sent along daily, if not more frequently. Out in the field, the Memphis office, designated the, quote, Office of Origin, close quote, initiated its investigation shortly after the assassination. While day-to-day direction of the case resided in Washington, Memphis had a pivotal role to play in the administration and coordination of the case. It was sent copies of most of the reports from 57 other domestic field offices. It initiated and coordinated leads, and it produced a prosecutive summary report after James Earl Ray's arrest in June 1968. There were no specific guidelines in 1968 for an FBI investigation of an assassination, but the King murder was promptly classified as a, quote, special investigation, unquote, and it was handled in a way that was quite distinct from that of the ordinary criminal case. Justice was flawed, not in pursuit of the fugitive, but in the search for others who may have been involved in the assassination. For example, there is reason to question the adequacy of the FBI response to substantial evidence of contacts between Ray and his brothers, Jerry and John, at various times between his escape from prison and the assassination. That evidence includes such items as, 1, the statements of several witnesses pointing to meetings between Ray and a brother. 2, denials by Jerry and John of pre-assassination contact with James that are in conflict with information established independently. 3, Missouri State Penitentiary records indicating John visited James the day before he escaped. 4, information that Jerry, on 2 occasions, admitted knowledge of a conspiracy in the assassination. And 5, Ray's statements to a salesman in a gun store just 6 days before the assassination that he wished to exchange the rifle on advice from his brother. Coupled with these indications of a possible family-based association that pointed towards a criminal relationship were indications that the mysterious Raoul might actually have been one or both of the brothers. Even so, the FBI never made a concerted effort to check out the possibility of a Ray family conspiracy in the assassination. Instead, it treated the brothers and other relatives almost solely as information sources as to James' whereabouts. In fact, the Bureau became so preoccupied with the fugitive search that on May 13th, Mr. Hoover recommended, with the concurrence of Mr. DeLoach, Mr. Rosen, and Mr. Tolson, the placing of electronic surveillance devices in the homes of John Ray, Carol Pepper, a sister, and John's place of business, the Grapevine Tavern in St. Louis. This clearly illegal action was never endorsed by the Department of Justice, but the request itself is disturbing enough. Not only does it show a lack of concern for constitutional rights of the relatives, it establishes the Bureau's lack of interest in a possible conspiracy involving the brothers. Had the taps picked up evidence of such a conspiracy, the illegality of the surveillance would almost surely have tainted the evidence in any subsequent conspiracy trial. Internal FBI memoranda, moreover, indicate that Mr. Hoover and his assistants were well aware of the problem, but made the request in any event. I would ask at this time, Mr. Chairman, photocopied, passed along to the FBI's Memphis field office, and subsequently transmitted to FBI headquarters in Washington. On October 31st, 1968, after a directive issued from headquarters No further letters were Xeroxed. MLK Exhibit F504, which I would request that be entered in the record at this point, is a copy of this headquarters directive.
Without objection, it may be entered into the record.
The second occurred shortly after Ray pled guilty in March 1969. Ray was interviewed by the agents in charge of the Memphis field office for the purpose of obtaining information on an assassination conspiracy. Ray was not accompanied by an attorney, nor was he informed of his Miranda rights, that is, his right to have an attorney, paid or appointed, present, his right to terminate the interview at will, his right to remain silent, and the fact that the government could use his statement by attorneys for the Department of Justice. It seems reasonable to attribute this to the state of relations between the Department and the FBI in 1968. That they were poor and counterproductive is demonstrated by Mr. Hoover's criticism of Attorney General Clark's press policy, FBI complaints of intrusion by the Department into its investigative territory, and a general lack of respect for the Department's leadership by the FBI. Departmental attorneys received digests of investigative reports, often in a superficial form and weeks late, as the day-to-day investigation was directed at FBI headquarters without consultation with the Department. This was the case even though it had been common practice in major conspiracy investigations, for example, in the antitrust and organized crime areas, for the Bureau and the Department to work together and to work together successfully. When major investigative steps were taken, an interview with Ray, for example, there was no participation by a departmental attorney, and not once during the investigation was a grand jury interrogation, with its sophisticated techniques such as immunity grants, put to use to prove or probe a possible conspiracy. The committee is aware that the blame for any deficiencies in the relationship of the FBI and the Department of Justice must be shared. While we are addressing the performance of the Bureau in today's hearing, that of the Department itself will be the subject of attention tomorrow. Mr. Chairman, the next witness, Cartha DeLoach, was one of two assistants to the Director Hoover between 1965 and Mr. Hoover's retirement in 1970. Mr. DeLoach supervised the activities of 4 separate divisions, which together constituted the Bureau's investigative arm. Included among them was the Domestic Intelligence, which managed both the security and the COINTELPRO cases against Dr. King, and General Investigative, which provided supervision for the assassination investigation. Mr. DeLoach, therefore, is in a unique position to comment on FBI programs against Dr. King and the performance of the Bureau in its investigation of his death. At this time, Mr. Chairman, it would be appropriate to call Cartha DeLoach.
The committee calls Mr. DeLoach. DeLoach, would you please stand, raise your right hand, be sworn. Solemnly swear the testimony you'll give before this committee is the truth, the whole truth, nothing but the truth, so help you God. Thank you. You may be seated. Would counsel for the witness please identify himself for the record?
Edward P. Morgan, Welsh and Morgan, Farragut Building, Washington, D.C.
Thank you, sir. Chair recognizes Staff Counsel Peter Beeson.
Can you hear me, Mr. DeLoach?
Very well, thank you.
Would you state your full name for the record, please?
Cartha DeLoach.
Would you give the committee a brief rundown of your employment history from the time you entered the FBI until your retirement from the FBI in 1970?
Yes, Mr. Beeson. I graduated from college in 1942. I entered the FBI in a clerical capacity, offices in Norfolk, Cleveland, in various capacities as a special agent of the FBI. I left the FBI in 1944 to go into service in the United States Navy during World War II. After being honorably discharged from the Navy in 1946, I returned to the FBI again as a special agent in Cleveland, Ohio. After serving there for some period of time, I was transferred to Washington headquarters of the FBI in 1947. In 1951, if my memory serves me correct, and it's been 9 years since I left the FBI, quite a long time, but I think I became an inspector in 1951. I became an assistant director in 1959, I believe, and assistant to the director in 1965, and retired in July 1970 after 28 and a half years service in the FBI.
Okay, if I could just cover a couple of points in that chronology. In 1959, you became an assistant director. Which division were you in charge of?
Crime Records Division, Mr. Beeson.
And in 1965, you became assistant to the director of Mr. Hoover. Would you describe briefly your responsibilities as assistant to the director of Mr. Hoover?
Well, as assistant director in charge of the Crime Records Division, I had supervision of one division. When I became assistant to the director in 1965, I had supervision under reporting to Mr. Clyde Tolson, who in turn reported to Mr. Hoover. I had supervision of 4 divisions. I was the General Investigative Division, which handled general criminal matters, the Special Investigative Division, which handled organized crime and special investigations, the Crime Records Division, which I had just left, which handled public relations matters, and the Domestic Intelligence Division.
All right. Now, the Domestic Intelligence Division was the division within the Bureau, Division 5, which was responsible for the security case against Mr. King. Is that correct?
The security case involving Mr. King, but the General Criminal Division handled the special investigation involving Dr. King's assassination.
Right, and that would be the General Investigative Division, which was Division 6 in the FBI.
That's correct, sir.
So in 1968, at the time of Dr. King's assassination, you were number 3 man in the Bureau underneath Mr. Tolson and Mr. Hoover, and had direct supervisory responsibility for the activities in both the Domestic Intelligence Division and the General Investigative Division, as well as other divisions, correct?
The facts aren't exactly correct, Mr. Beeson. We didn't play the numbers game. There was no number 3 man or no number 4 man. There were 2 assistants to the director. I was assistant to the director in charge of investigative activities and crime records, which included public relations, and Mr. John P. Moore was assistant to the director in charge of
as liaison with the Department of Justice.
I have read your report, Mr. Beeson, and it states that, but frankly, I have no such recollection of any Mr. Clark calling Mr. Hoover whatsoever and terminating me as liaison. As a matter of fact, let me make it very clear to the committee and to you, sir, that I was never established, to the best of my knowledge, as liaison with the Department of Justice. There was no such title, in my opinion. I took it upon myself to keep the Attorney General advised because I had a very close personal friendship with him and close relationship with him.
Was there any other headquarters official who was more involved in briefing of Mr. Clark during the assassination investigation than yourself?
No, sir.
Okay, I did not mean to imply that there was an official designation of liaison, but that was, in fact, one of the roles that you served during the assassination investigation, correct?
But I do not recall Mr. Clark calling over and indicating that my services should be terminated as liaison to him. It may have happened, but I certainly don't recall it.
In other words, if Mr. Clark were to testify to that effect, it's your opinion that his recollection would be erroneous on that matter?
I have no recollection of Mr. Clark calling Mr. Hoover. As a matter of fact, Mr. Hoover, to the best of my knowledge, never told me that I was terminated or that I should not see the Attorney General or officials of the Department again. As a matter of fact, Mr. Beeson, I quite frequently conferred with the Department of Justice following the apprehension of James Earl Ray on many cases.
Let me ask you this, Mr. DeLoach. Did you confer specifically with Mr. Clark?
Not to my knowledge, sir.
Following the apprehension of Mr. Ray?
No, sir, I would not have unless Mr. Clark called me, and I did not take it upon myself to contact Mr. Clark. I have seen Mr. Clark since then, within recent months, and we had a very cordial, brief conversation and shook hands. There's no, to my knowledge, at least certainly not on my part, there's no feeling of hostility towards Mr. Clark.
Well, if I understand your testimony correctly, you met with Mr. Clark on a daily, if not on a weekly, if not daily basis prior to Mr. Ray's arrest. You have no recollection of meeting with him after Mr. Ray's arrest. Is that correct?
After the isolated incident that I referred to, sir, I have no recollection of being with him. It may have happened, sir, but I don't recall. Memorandum, I don't recall this, but as I say, my memory has been refreshed after reviewing your report. Down in the third paragraph, where it was said in the memorandum dictated by Mr. Long, that John Larry Ray has expressed a cooperative attitude. However, it is felt that he is not giving us complete and accurate information. Carol Pepper refuses to submit the interview and is not cooperative. It is felt that if the subject, meaning James Earl Ray, telephones or personally contacts any of the relatives, it will most likely be Carol Pepper or brother John Larry Ray. There obviously is a second reason, too, Mr. Beeson, up in the first paragraph. These installations could assist in the early apprehension of the subject. Now, we were spending hundreds of thousands of dollars of the taxpayers' money. We had the FBI tied up to a great extent on this particular case. There was an overall overriding other reason, again on sheer speculation, why we thought it was necessary. And that was expelled out in this sentence, which could possibly be instrumental in reducing the stresses and tension placed on our national security subsequent to the death of Dr. King. The assassination of Dr. King caused considerable burning, caused pillaging, it caused rioting throughout our country. It was a time of stress and strain, and just my own opinion at this late date that the FBI was very anxious to cause an early apprehension of the subject and a solution of this case as early as possible. Now, as to the legality or illegality, Mr. Beeson, that is a matter entirely up to the Department of Justice. The FBI can recommend investigative leads to the department, but as a matter of this nature, as the committee well knows, at that particular time, the FBI was not placing any wiretaps or microphones, and to the best of my knowledge, unless they had the approval of the Attorney General. And the FBI felt that if the Attorney General did approve, this would be sufficient legal status. So there was no question in the FBI's mind as to the legality or illegality. It was a matter of putting an investigative lead up to the Attorney General of the United States.
Okay, well, right now, if you're responding, I'm sorry that I cut it off. It is doubtful that the AG will approve. What were you thinking of at that time when you were speculating about the possibility of having this proposal rejected by the Attorney General?
Mr. Clark's philosophy that he was against wiretaps unless they were under the aspects of national security. As expressed in this memorandum by Special Agent Long, he felt this did have a connotation of national security in view of the rioting and pillaging and burning that was going on in our country. However, I felt that that was not a strong enough case, and the Attorney General would probably disapprove, as later turned out to be the case.
To the best of your recollection, Mr. DeLoach, is it not a fact that 5 weeks after the assassination, the major portions of the rioting and pillaging had subsided in the country?
Yes, but some was still going on, Mr. Beeson, to the best of my knowledge. Okay. And it could arise at any time. The situation was still tense. Washington has never seen such things as went on during the middle and late 60s. Brickbats thrown through the windows of the Department of Justice, the Pentagon stormed, bombs going off in various hallowed institutions. There was a very bad feeling in our country at that time.
I just want to clarify the record. The situation that you're currently describing was not going on in Washington as of May 9th, was it, Mr. DeLoach? Bombs going off.
As of what date, Mr. Beeson?
As of May 9th, the date of this memo, bombs going off, fires, pillaging.
I don't recall whether it was or not, Mr. Beeson.
Okay.
But throughout the country, there was considerable tenseness.
If I could ask you to refer to Martin Luther King Exhibit F-502, the next memorandum in your pile. And if you'd like to familiarize yourself with that, I'll describe it for the record. It is a memorandum sent from Mr. J.J.
Concerned about the national security of the United States, about the incidents I mentioned previously, and also a very fervent desire to apprehend the man responsible for the assassination of Dr. King. As a result, they forwarded an investigative lead to the Attorney General, and the Attorney General was to make the decision as to whether or not this should be conducted.
All right, Mr. DeLoach, do you recall any consideration given to the taint problems that this recommendation could raise in a possible conspiracy case against relatives of the Ray family? Make it clearer, evidence intercepted by these taps, if they had been installed, would not have been admissible against any of the family members of Mr. Ray because it was unconstitutional. In addition, that evidence could not have been used as the basis for any type of investigation against the family. Did you consider the possible jeopardy that you were posing to a possible conspiracy case against family members of Mr. Ray when you recommended this proposal?
The question is moot, Mr. Beeson, because as I've testified previously, I don't recall the memoranda at all, so consequently I don't recall any taint that was considered over 10 years ago, 10 and a half years ago. It does express to me a very sincere desire on the part of the FBI to look into all aspects of the case, including the possible conspiratorial aspects of the case.
Okay, Mr. DeLoach, in June of 1968, final question on electronic surveillance. Title III was passed. It was a congressional federal statute, which provided a basis for legal court-authorized electronic surveillance in certain criminal investigations. Do you recall any additional consideration being given to the use of legal electronic surveillance in this case following the passage of Title III?
I have no such recollection, Mr. Beeson.
All right, one final area of questioning.
Witnesses before this committee that there is a conspiracy. When I left the FBI in 1970, over 8 years ago, I believe that. I still believe that. I do think that just as in the assassination of President Lincoln, who was assassinated, 114, 115, 116 years ago, that from time to time people will write books, people will attempt to exploit the situation, people will attempt to make money out of the situation, people will attempt to bleed the taxpayers by trying to perpetuate their own names and reputations out of these unfortunate incidents. But again, I repeat, to the best of my knowledge, there is no conspiracy, and I do agree with these statements. But at the same time, I think that the committees of this nature do a very valuable service to the people of the United States and to the Congress by assisting in running down the leads and by putting out more or less the fires of emotion that happen from time to time as a result of such unfortunate incidents. I think that the FBI in all instances should continue to run down leads that come up to prove whether or not there is a conspiracy. But as of this time, and based upon my knowledge of the case, admittedly, many years have passed, but nevertheless, I know of nothing which would indicate a conspiracy. Here you had a subject that was a loner, an egotist, a bigot, a man that had verbally in prison threatened to kill Dr. King or said he was going to kill Dr. King, a man that hated blacks, a man that wanted to be known, a man that stalked Dr. King, and the evidence is overwhelming that he did assassinate Dr. King.
You've had an opportunity to review the staff report concerning the conspiracy investigation, which was conducted by the Department of Justice and the FBI. The report finds evidence and indicates a failure of the FBI and the Department of Justice together to adequately explore the possibility of family involvement in the assassination investigation. Would you care to comment on those findings?
Your report makes that allegation, Mr. Beeson, but on the other hand, your report is somewhat contradictory in that you said there was an intense effort to interview the family and to bring pressure on the family, not to bring pressure, but to stick with that phase of it, to continue interviews, and there were frequent interviews with the family. Given the example of the fact that the FBI at a late date wanted to put an electronic surveillance, if the Attorney General, the highest legal officer in the United States, had approved, that was a direct example of the FBI bringing pressure, or at least attempting to find out if there was a conspiracy involving a particular family.
Mr. DeLoach, isn't it clear from your recent review of the documents surrounding the electronic surveillance request that the sole purpose stated for implementing that request was to attempt to ascertain whether Mr. Ray made contact with family members in order to locate the subject? In other words, that the use of the electronic surveillance there was not in order to ascertain possible evidence of a conspiracy, but only to attempt to track down a fugitive in the case.
While the memorandum may have not reflected that, Mr. Beeson, I feel certain it was in the minds of the FBI, and certainly it was in my mind at the time, that any phase of the investigation, including the conspiracy that come about as a result of that wiretap or microphone surveillance, would have been beneficial to the FBI, providing the Chief Legal Officer of the United States, the Attorney General, had given authority and thought it had been legal.
Don't you think it would have made a stronger authorization request to the Department of Justice to include as one of the reasons for it possible interception of evidence of a conspiracy, if in fact that was in the minds of the FBI agents involved with this request?
I doubt the necessity of the supervisory and determining whether or not other people were involved in this that might lead to the apprehension of Ray. The very fact that he wanted to find out if the relatives were involved certainly indicates a feeling that the FBI had to run down any conspiratorial elements.
Mr. DeLoach, I don't have any further questions for you myself. Thank you very much.
Thank you, sir.
Okay. This time the chair yields himself such time as he may consume, after which the committee will operate under the 5-minute rule. Mr. Loach, you're aware, I'm sure, that the committee has received testimony from several former agents prior to your testimony here this morning, two of whom were Mr. Brennan and Mr. Moore, whom I'm sure you also know. Based upon testimony already received, let me ask you
Mr. Chairman, excuse me, sir. I have not seen their testimony. I have seen newspaper accounts referring to...
Yes, I didn't mean to indicate that you had seen a testimony.
Yes.
I thought perhaps you were aware of the fact that they had testified.
Yes, sir. I'm sorry to interrupt you.
Right, certainly. Let me just ask you then a couple of general questions. Maybe we can avoid some in-depth interrogation on a couple of subjects. Would you agree that between 1962 and April 4th of 1968, that the Bureau conducted a security investigation of Dr. King and the Southern Christian Leadership Conference to determine the extent of communist influence being exerted upon them?
Mr. Kennedy, the Attorney General of the United States, first requested, and I'm testifying strictly from knowledge, several months later, when it was discovered that there was a possibility of Dr. King being affiliated with a high-ranking member of the Communist Executive Board or Board of Trustees or whatever it was, Mr. Hoover brought that to Mr. Kennedy's attention immediately, and Mr. Kennedy at that time authorized the surveillance. That did initiate the surveillance on Dr. King, and it was handled by the Domestic Intelligence Division. As I say, I did not have supervision of the Domestic Intelligence Division, so consequently my memory is somewhat hazy.
Okay. Would you agree that between 1963 and 1968 that the Bureau engaged in a campaign to discredit and neutralize Dr. King as an effective civil rights leader?
Mr. Chairman, if I may, I'd like to answer that question in this way. Dr. King made an allegation that FBI agents were not to be trusted in the handling of civil rights cases in Albany, Georgia. That cast grave doubts upon the integrity of FBI agents in the handling of civil rights cases. In those particular cases, the FBI was damned if you do and damned if you don't. In certain states, agents had rattlesnakes put in the driver's seat of their car so they would be bitten when they sat down. Agents were spit upon. Agents were refused service in restaurants. One agent, wife, heard a knock at her door on one occasion, and she went to this door, the front door, and here were 4 men carrying a coffin, and they simply told her that her husband's body was contained in that coffin, dumped it on the floor, and left. What I'm trying to point out, it was hard enough to investigate the civil rights cases at that time without allegations being made casting aspersions against the integrity of FBI agents. Now, I can easily understand that Dr. King, in an emotional moment, might have made the statement, but it was not a true statement. The fact was that 4 out of 5 agents in Albany, Georgia, at that particular time, were northern-born, reared, and educated. But this touched off a feud between Mr. Hoover and Dr. King. In my opinion, it was a very unfortunate feud. I had to regard not only the public relations of the FBI, but the investigative aspects of the FBI in handling civil rights cases. We needed all the sources we could get. And this, of course, alienated civil rights sources for Mr. Hoover to come out at a ladies' press conference, which was the first one he ever held, and to indicate that Dr. King was the most notorious liar in the United States. As I say, I was against him making that statement, and I think the feud was very unfortunate. I think the campaign was very unfortunate that you allude to, Mr. Chairman. I sent Mr. Hoover during that press conference with 22 ladies 3 different notes asking him to withdraw that statement or to at least indicate to the ladies it was off the record. This is the Women's National Press Group in Washington area. He refused to do so. On the 3rd occasion I sent him a note. He said, "You mind your own business." And the ladies could not wait to get out of the room and report this to the wire services in their own papers. But this touched off a feud between Mr. Hoover and Dr. King. Allegations flew back and forth. Dr. King called Mr. Hoover senile and said he was bowing under the weight of his own office. Mr. Hoover again repeated his notorious liar statement. Mr. Hoover repeated this in a statement later on to a reporter, and I asked the reporter if he would withdraw the statement from his article because it was causing the FBI difficulty from a public relations standpoint. But it did become more or less of a feud between the 2 men. I was responsible for trying to contact Dr. King. Dr. King would not return my calls. I did eventually talk to the now ambassador to the United Nations representing the United States, and we arranged jointly the meeting between Mr. Hoover and Dr. King, and it turned out to be a very peaceful meeting. To specifically answer your question, there was a feud. There was a campaign which Mr. Hoover more or less carried on and supervised, and there was, unfortunately, various incidents which occurred back and forth between the 2 men, mostly on Mr. Hoover's part, to discredit Dr. King. To specifically answer your question, Mr. Chairman.
So when we strip your answer of the surplusage, the answer to my question would be yes, wouldn't it?
Yes, sir, it would.
Chairman,
certainly yield to the gentleman from District of Columbia.
It appears that the burden of Mr. DeLoach's testimony is that the feud began or surfaced at the time that Mr. Hoover had a press conference in 1964. Is that your testimony?
That's when Mr. Hoover answered Dr. King insofar as the Albany, Georgia allegation is concerned. That's my recollection, Mr. Fauntleroy.
Were you aware that Mr. Hoover exhibited hostility for Dr. King much earlier?
I'm not aware of that, sir.
You're not aware of a memo?
At least I don't recall that, Mr. Fauntleroy.
Thank you, Mr. Chairman, for yielding, and I'll look forward to my 5 minutes.
Mr. DeLoach, let me ask you this. The comments that were made by Dr. King with reference to the FBI and Albany had occurred some 2 years prior to the statement made by Mr. Hoover at the press conference when he called Dr. King a notorious liar, had it not?
I don't recall the specific dates, Mr. Chairman.
Well, the press conference was in 64, was it not?
I don't recall, sir.
Don't recall. You don't recall that the Albany situation occurred in 1962?
I don't recall that, sir. In the best of my opinion, the best of my knowledge, the 2 incidents were quite close together.
Okay. Are you aware of the fact that Mr. Murtaugh, a former FBI agent, testified before this committee, and with reference to the FBI and their investigation of civil rights violations and complaints, testify before this committee that the FBI was dragging their feet?
Mr. Chairman, I have every respect for you and every respect for this committee, but I wonder if any member of this committee or any member of the staff can name one FBI case where the FBI dragged its feet in the civil rights field. I don't recall any.
I'm referring to the testimony of a former FBI agent.
Yes, sir.
Before this committee.
Yes, sir. And I don't mean to discredit Mr. Murtaugh in any way whatsoever. I have not seen his testimony, but let's consider Mr. Murtaugh for a second, Mr. Chairman. Mr. Murtaugh was never a supervisory agent, and to the best of my recollection, Mr. Murtaugh was an agent assigned to the Atlanta, Georgia office. He was never assigned to FBI headquarters in Washington, D.C. Mr. Murtaugh had no overall knowledge of the FBI or of its responsibilities. Mr. Murtaugh had no overall responsibility or knowledge of the immense field of civil rights investigations, only those perhaps in his narrow sphere of category in Atlanta, Georgia, or the surrounding area. To be an expert witness, and I'm not alluding to the fact that I'm an expert witness, because there are many things I don't know that may have happened at that time. But to be an expert witness and to make sweeping statements as he made before this committee, he should have at least had some supervisory responsibility or knowledge of the overall responsibility of the FBI, which he did not have. He was only one agent among some 8,500 agents that was assigned to the field at that time. I had never heard of Mr. Murtaugh until he started testifying before, or volunteering to testify before various committees.
Well, wouldn't you agree that this is not necessarily an area where one must possess expertise if one is testifying as a result of his having been an employee stationed in that particular branch of the FBI, and testifies before this committee as to his own personal knowledge and observations? That doesn't require his being an expert in that area, does it?
Well, Mr. Chairman, it would depend entirely upon why that individual wanted to testify, or what was his reason for testifying, or whether he had an axe to grind against the FBI. Had he written a book previously? Did he want publicity? What was his reason for testifying?
Well, Mr. Murtaugh is a former agent who retired on honorable conditions. He is presently a professor of constitutional law at a university who twice or three times during his testimony before this committee.
Do you question his knowledge?
I'm not aware of the incident, Mr. Fauntleroy.
But do you question his knowledge?
I don't know whether I can question it or not, Mr. Fauntleroy. I'm not familiar with the incident.
Do you question his knowledge that a request was made of him to find an informant, to get copies of SCLC stationery and copies of the handwriting of Andrew Young, so that it might be used against him in his effort to be elected to the Congress?
Again, Mr. Fauntleroy, I'm not aware of the incident that you speak of. I'm only aware of Mr. Murtaugh's background or assignment as an agent, and the fact that he did not have overall knowledge of the responsibilities of the FBI.
You questioned that he had specific knowledge of what was happening in that office, knowledge that perhaps you were not aware of.
I quit. Certainly the things that happened I may not be aware of, Mr. Fauntleroy, but I do question his knowledge concerning the sweeping allegations he's made concerning the FBI.
Were you aware that the
civil
FBI
rights
was spending the time and money of 15 agents full time to surveil Dr. King and SCLC?
I have no knowledge of that, Mr.
Thank
Fauntleroy.
you,
Mr. DeLoach, let me ask you this. Would you agree that the campaign
high-ranking members of Congress to obtain information concerning Dr. King and Mr. Hoover approving giving this information to those high-ranking members of Congress? And I do recall that Mr. Hoover from time to time not only furnished information to the Attorney General but to the White House concerning information concerning Dr. King.
Well, in terms of this COINTELPRO operation, you had a specific role, did you not?
No, sir, not a specific role. I'd like to make the record clear in that regard, Mr. Chairman. This program was initiated while I was on the administrative side of the House. I had nothing to do with the initiation of this program. It was initiated by Mr. William C. Sullivan, who was the Assistant Director in charge of the Domestic Intelligence Division, and Mr. Alan Belmont, who was the Assistant to the Director at that particular time. They supervised and operated that program under Mr. Hoover long before I became Assistant to the Director. After I became assistant to the director and inherited this program under Mr. Tolson and Mr. Hoover, why, then I knew about it. However, up until that time, I was not prior to all aspects of this particular program.
Well, the program started August 25th of 1967. What were you doing?
I put on the bottom that I doubt this would be of any purpose. I did, the memorandum dated October 26, 1966, 12 years ago. It's designated as D-31 MLK 449C. That appears to be my memorandum, Mr. Chairman, and where I talked with Mr. John Bugas, who was the vice president of the Ford Motor Company, and discussed with him the facts contained therein.
You're not testifying from your own knowledge.
I will testify to my own knowledge, Mr. Chairman. I don't know whether, frankly, in my own opinion, where Dr. King could be classified as a member of the Communist Party or not.
And with reference to your statement about someone high in the party exerting influence over him, do you have any knowledge of that?
I recall, to the best of my recollection, there was such a man, Mr. Chairman.
And you tell the committee then how you know that this man had influence over Dr. King.
I was told, Mr. Chairman, and again I'm testifying from facts of 10, 11 12 years ago, and even beyond that, Mr. Chairman, that this man wrote speeches for Dr. King, that this man gave financial advice to Dr. King, that this man made policy decisions for Dr. King, and consequently, having been told that, there certainly would have been some association between this individual and Dr. King.
You familiar at all with Dr. King's intellectual and educational attainments?
I have read some of Dr. King's sermons, Mr. Chairman, from the standpoint of my own knowledge. I know that he was a symbol of leadership of the civil rights movement. I have not gone into depth as to Dr. King's intellectual education, no, sir.
Well, maybe it would help you if I said to you that Dr. King graduated from Morehouse College with honors, graduated at the top of his class from Crozier Theological Seminary, then acquired a doctorate of philosophy from Boston University. And upon what hotel rooms, what did they do to stop the infiltration of the civil rights movement by the Communist Party?
Well, I think FBI communications, both to the Attorney General and to the White House, on occasion calls the Department of Justice to brief civil rights leaders as to the dangers involved. And to the best of my recollection, and I'm not clear on this, Mr. Chairman, I think that FBI communications to the White House calls White House officials on occasion to brief civil rights leaders to the dangers involved. And in my opinion, even at this late date, that certainly would have assisted the civil rights leaders in knowing who was trying to undermine them, to infiltrate them, and to cause them to be wary. I think Mr. Hoover's meeting with Dr. King, where Mr. Hoover indicated that he should be very careful of his associations with certain people, assisted Dr. King from then on in being wary of such associations.
Then you really feel that that a man who had the education and intelligence of Dr. King needed Mr. Hoover or somebody else to tell him about the dangers of the Communist Party infiltrating the civil rights movement in America?
Not necessarily that isolated incident as example, Mr. Chairman, but I do feel that men with equal brilliance over the years have been taken in by the Communist Party and by communist subversion. I do feel there have been unfortunate instances in our society where great men of stature have been taken in, have possibly even become Soviet espionage agents. And therefore, I say with some gratification that the communists, in my opinion, failed miserably to take over the civil rights movement or to make a dent in the civil rights movement.
Mr. DeLoach, you were familiar with the conditions existing in this nation that brought about the civil rights movement, aren't you?
Yes, sir.
You know that at that period of history that all over the South that blacks and whites
that there is evidence of which I think the FBI was aware that seems to cut the other way, which would seem to show that he was not such an intense racist, and that his motive could have been something else. For example, money. For example, I believe the FBI was aware that he had frequented a bar in Los Angeles for some period of time when he was there, and that bar was about a 1/3 black clientele. And apparently he visited there regularly without expressing any racial feelings. There is evidence of a liaison with Miss Morales in Mexico, and possibly with Miss Marie Martin in Los Angeles, both of whom appear to be women of color. My question is, did these incidents raise any questions in the minds of the FBI concerning racism as a motive? Do you consider those are consistent with racism as a motive for the killing?
Mr. Pryor, I don't remember those specific incidents. I do remember that Dr. King, while in prison, according to the investigation, to the best of my recollection, I'm sorry, sir, when James Earl Ray was in prison, to the best of my knowledge, he refused to go on work orders out on the prison farm with blacks because of his dislike of blacks. And I think also that, to the best of my knowledge, that on one occasion he told an inmate in prison that he was going to get Dr. King. He did have a general reputation, I believe, in prison as being bigoted, anti-black. As to specifically answer your question, and I would like to do that, sir, if I had the knowledge, but I don't recall those specific incidents you're mentioning, such as frequenting bars with black women or attempting to engage in social activities with black women. I don't recall that, sir. In my opinion, he was he definitely hated blacks. He definitely was a loner. He was a bumbling, yet at the same time a very cunning individual. And I think that because of being a bigot, a racist, that he wanted to kill, in his opinion, the biggest man he could find in order to make a name for himself. As more or less attested by the fact that his brother on one occasion told, whether it was FBI agents or not, I'm not sure, but told someone that, I believe it was the FBI, but again, I'm not sure. But anyhow, he said, why all this fuss, the FBI making all this fuss trying to find my brother? All he did was to kill a nigger. This, in my opinion, expresses the anti-black feeling of not only King, but that of his family.
Well, I certainly grant you there is ample evidence of that sort of racist attitude, and there is evidence from his prison experiences of the kind you mentioned.
To the committee, I believe that would be a gross exaggeration insofar as possible loss of interest is concerned. I think, and I'm not with the FBI today, and I haven't been with them for almost 9 years, but I think the FBI is still interested in this case and will still carry out any leads with respect to any conspiracy, not only in this case, but in the Kennedy case and any other cases that are received of a major nature. To my knowledge, that case is still pending in the FBI and will never be closed as long as leads are still being received. But the fact that a fugitive investigation has been completed certainly would curtail the usage of automobiles, would curtail to some extent expenditures. But it does not mean that the FBI has lost interest in the case. It just means that one phase of the case has been completed and they're still working on other phases of the case, such as the conspiracy angle.
But did you, while you were still in the Bureau and still in a high supervisory capacity, issue any orders or direct any orders from Mr. Hoover to discontinue active participation in the investigation of the King case following the apprehension?
No, Mr. Devine. To answer your question, I believe that Inspector Sullivan, who was a major case inspector, was called off for other duties following the location of James Earl Ray, because the FBI felt that he was the man that had assassinated Dr. King, and whether any other curtailment of activities at that time or not, I don't recall, but definitely the case was still kept in a pending status, and definitely was every lead was still investigated very thoroughly.
On another issue, Mr. DeLoach, earlier I think you testified that you never heard of Agent Murtaugh prior to his appearance before this committee. And if I accurately recall some of Mr. Murtaugh's testimony, he said that he had never met Mr. Hoover personally, although he'd been in the Bureau for 10 or 11 years.
It became not only thinkable, but could be thought to have been justified in the nation. And I wonder if you think the FBI officials should have known that their conduct in not only writing articles like this and seeing to it that they were disseminated around the country could have unjustifiably risked the life of Dr. King?
What was the last part of your question, sir? I'm sorry.
Is it your opinion that the FBI should have known that the kinds of activities to which we've referred in these memos would unjustifiably risk the life of Dr. King?
Mr. Fauntleroy, I think it'd be absolutely ridiculous to assume that any of the FBI's few attempts to discredit Dr. King as ordered by Mr. Hoover or Sullivan or whoever participated in that caused an atmosphere which would have resulted in his assassination. I doubt if James Earl Ray had ever seen any of the articles, the 1 or 2 or 3 articles which were put in the newspapers, which you've shown me here today. Well, no one has shown me the articles. I don't know whether they even appeared or not, to tell you the truth. But I doubt if James Earl Ray, or I doubt if anyone to amount to anything has ever seen any of the articles that, if they did appear, that had been perpetrated by the FBI or knew of the discreditation program to any extent. So consequently, in my opinion, the facts would overwhelmingly indicate that the FBI did not create any atmosphere which had caused harm to Dr. King from a physical standpoint or, in my opinion, any other standpoint.
In your testimony, Mr. DeLoach, you allude to the fact that over the years the FBI had compiled files on death threats directed at Dr. King. Is it fair to say that at the time, this period between 1963 and 1968, that it would not have surprised you that Dr. King received death threats?
I wouldn't have been surprised, sir. I think almost any individual in the public limelight, as Dr. King was, or any public leader in our society today, received death threats.
Well, again, in view of those death threats, and in retrospect, didn't the release of derogatory and inflammatory information describing as a traitor to the race and the country run the risk of further poisoning the minds of people who might violently oppose what Dr. King stood for?
Well, again, sir, I was not on the investigative side of the House at the time that language was used, and frankly, I'm not aware of the fact that such language was ever given out from a public standpoint. That appeared to be Mr. Sullivan's usage of inflammatory language, and whether it was given out or not, I'm not aware of that fact, Mr. Fauntleroy.
I just read to you and you have before you the Martin Luther King Exhibit 450A.
That's correct, sir.
Which has to do with the Houston article. Were you not...
I don't recall the article, sir.
You don't recall?
No, sir.
You don't deny the FBI did that, do you?
I don't deny that Mr. Brennan made this request and that Mr. Hoover ordered it be done, but...
Is that your initial at the end of that memo?
It is, sir. Yes, sir. The natural flow of mail went through my office and on into Mr. Tolson and then on into Mr. Hoover. And in these particular cases, Mr. Hoover indicated that anything pertaining to this matter he should see personally and make a decision.
So you didn't read this?
Beg pardon?
You didn't read this?
I did not read it.
What does your signature mean then?
My signature...
I mean, your initial.
My initial means that this piece of mail was received in my office, and I read it, and I sent it in to Mr. Tolson's office approximately 11 and a half years ago.
And it doesn't mean approval?
It means that I thought that Mr. Hoover should see this piece of mail. That was my duty, to weed out mail which he should not see and to approve it and send it on my own, or else send it on into him for final approval.
So finally, Mr. Chairman, I appreciate the extent to which you've allowed me to go on. In your view, the FBI was not sensitive to the possible implications of the derogatory information it attempted to disseminate around the country about Dr. King as a traitor to the race and to the nation for his own life.
No, Mr. Pomeroy, I simply stated this, that the few attempts on the part of the FBI to discredit Dr. King, as ordered by Mr. Hoover, did not result, in my opinion, an atmosphere which would have caused physical harm to Dr. King.
Carrying out of this campaign against Dr. King, were you aware or sensitive to the fact that this might result in creating a climate within which Dr. King's life might well be taken?
Mr. Pomeroy, I can't answer that question because, as I testified previously, the greater majority of these memoranda took place prior to my assuming any supervision of the investigative divisions of the FBI.
Yes, I went through
but
those.
I am not aware of any overall feeling of hysteria that resulted as a result of the FBI's actions.
Yes.
Just sheer speculation at this late date. I'm trying to testify to the best of my ability.
But you recall never having anyone either in a discussion or by memo expressing some concern about the effect that this campaign could have upon Dr. King's life.
I have no such recollection, Mr. Pomeroy.
Thank you, Mr. Chairman, for your thanks.
Time of the gentleman has expired. I'd like to have the...
FBI did a marvelous job, by the way, tracking down how much money it spent here and there, and remarkable investigative. And I compliment you for whatever part you had in that, by the way. I think it was a superb investigation on that level.
Thank you, sir.
But the man did sustain himself for a considerable period of time and spent a considerable amount of money over that time. Shouldn't it have loomed in someone's mind that that he had to get that money from somewhere?
Yes, sir, and it did in our mind, Mr. Fithian. I allude to the possibilities of a bank robbery investigation in Alden, Illinois, and there was an intense investigation by the FBI to determine whether or not James Earl Ray was involved in that bank robbery. And as a matter of fact, to the best of my recollection, several witnesses indicated that his physical characteristics were very closely resembled one of the bank robbers in that bank robbery.
Is it your opinion that...
If I may complete this, sir, excuse me, but to the best of my knowledge, there was some $44,500 involved in that bank robbery, or even more, which would have given him ample funds to carry out his various travels and his stalking of Dr. King.
So is it your judgment or your best guess that that's the way he financed himself?
That's my opinion, Mr. Fithian.
And the passports that he managed to manufacture, that did not raise any problem for you?
Well, as you'll recall, sir, in Canada at that particular time, the laws have since been changed, but it was very easy to get a passport.
So you don't think that there had to be any assistance on that score?
Not as far as passports are concerned, no, sir.
Now, you made one request to surveil the family members, as I understand it, the electronic surveillance. I didn't quite understand. Are you...
James Earl Ray killed Martin Luther King, and to the best of my knowledge, there are no facts to indicate a conspiracy at this date and time.
Thank you, Mr. Chairman.
Time of the gentleman has expired. Chair recognizes Professor Blakey.
Mr. Chairman, I wonder if I could ask Mr. DeLoach.
That's correct, sir.
And that at least my effort or my concern in that commission was on the organized crime task force.
That's correct.
I'm sure you recall that. And that task force recommended to the commission, and the commission ultimately adopted a recommendation that said that the investigation of sophisticated conspiracies required the integrated use of a compulsory process in the context of a grand jury, immunity techniques, and electronic surveillance. I'm sure you recall those recommendations.
I don't recall it specifically, Mr. Blakey, but it sounds logical.
And you have testified here this morning that you were satisfied with the contours and development of the King conspiracy case, even though it did not involve, except perhaps one small suggestion, the use of a grand jury. It never involved any effort to secure testimony through immunity grants, and the only electronic surveillance was the one that was suggested by the Bureau but not adopted by the Department, that could not have obtained lawful evidence of a conspiracy. That's correct, isn't it?
I've given my opinion concerning that, Mr. Blakey, yes, sir.
I'm sure you may also recall with me that in 1968 the Congress passed the Crime Control Act of that year that gave to the Department of Justice fairly extensive immunity power in 18 U.S.C. 2514 and wiretapping authority in 18 U.S.C. 2516. Recall that?
I don't recall that, no, sir.
Would you accept my statement that in fact did occur?
Certainly, sir.
Okay. Suppose I was to tell you, Mr. DeLoach, that this committee, since it began its investigation of this matter, utilizing its executive session as if they were a grand jury, and utilizing its congressional subpoena power as if it were a grand jury subpoena power, and utilizing the immunity techniques that were granted to the Congress by the Organized Crime Control Act of 1970, was able to pick up on information that reasonably could have been available to the FBI in 1967, and through utilizing those techniques recommended by the President's Crime Commission in 67, but not utilized by the FBI or the Department of Justice together or separately in 1968, was able to develop, even 10 years after the fact, the outlines of a conspiracy case that may well have involved the individuals who plotted the death of Dr. King, and may well have involved actually bringing about the events in Memphis. If that were true, would that lead you to reconsider your judgment that what was done in 1968 was satisfactory?
Mr. Blakey, I've testified to the fact that, to the best of my knowledge, I knew of no conspiracy involving the assassination of Dr. King. And to the best of my knowledge also, in my opinion, definite opinion, James Earl Ray committed this crime. I am not aware of any additional facts, and you have not given me any facts, which would indicate that there is a conspiracy.
No, Mr. DeLoach, let me see if I can't go back again. Suppose I suggested to you that this committee had been able to obtain that kind of evidence, utilizing in however a fashion in a congressional context those techniques. And in other words, I'm telling you in fact that evidence was developed. Would that lead you to reconsider your judgment that you were satisfied with what happened in 68?
If you could show me any facts which indicate a conspiracy, Mr. Blakey, I would certainly be glad to reconsider. Okay. But as your report indicates, you have no evidence indicating a conspiracy, something to that effect, plus the fact...
Mr. DeLoach, I'm not aware that report indicates that.
Well, you indicated you would not rule out a conspiracy, but you did not indicate that you had facts indicating a conspiracy. To the best of my knowledge, after scanning your report...
Well, I suspect the record will have to speak for itself on that. Let me ask you one other question that's related to that. In response to Chairman Fauntleroy's question, you indicated that you did not feel that the FBI's harassment and propaganda campaign directed at Dr. King, in fact, so created an atmosphere that the assassination may have occurred as it did in Memphis, because no evidence had been brought to your attention that James Earl Ray or others that he may have been associated with had ever been reached by that propaganda. Suppose I were to tell you that this committee has in fact developed evidence that, to some degree at least, that circle of people who may have plotted the death of Dr. King and whose actions may have contributed to James Earl Ray's conduct in Memphis was in fact touched by the FBI propaganda campaign.
I'm not aware of that, sir. I have no such
Well,
facts.
but Mr. DeLoach, the question is, suppose I told you that this committee has developed that evidence. Would that lead you to reconsider the degree to which the FBI may have to be responsible in some degree for Dr. King's death?
Mr. Blakey, if you could show me indisputable facts, certainly I would reconsider, but you have shown me no such facts.
Thank you,
asked me
Mr.
for
DeLoach.
my opinion, I gave you my opinion.
I have no further questions, Mr. Chairman.
Mr. DeLoach, you have indicated there were certain documents that you'd like to provide for the record and have included in the record here today.
Mr. Chairman,
you have those now?
Respect shown me by this committee. I hope that I've been able to be of some service to the committee and to the Congress. That's all I have to say, sir.
Okay. Well, we certainly thank you very much, Mr. DeLoach, for your appearance here and for the testimony you've given us.
Thank you, sir.
There being nothing further at this time, you're excused, sir.
Thank you, sir.
Okay. The chair at this time desires to make a statement. During the Kennedy assassination hearings, when we turned to evidence of association and its implications for conspiracy, it occurred to me that it might be appropriate to discuss certain general principles that seem applicable. Conspiracy is founded in association. I said then, but more than association is required to establish conspiracy. I hoped at that time to assist those who followed our hearings or read our record to understand the significance of what we were doing. It seems to me now that it would be appropriate to discuss for the record the moral or legal standards the committee might want to use in evaluating the evidence on the ultimate question, as it has been put to us, did the FBI kill Dr. Martin Luther King, Jr.? Our earliest legal traditions, those rooted in English common law, reflect an abhorrence of the unjustifiable taking of a human life. Lord Coke, a 17th century textbook writer, formulated the classic definition of murder: when a man of sound memory and an age of discretion unlawfully kills any reasonable creature in being, and under the king's peace with malice aforethought, either expressed or implied by the law. Much of our legal learning on homicide has been based on the concept of malice aforethought. The distinction between murder and manslaughter turned on it. Unjustified killing with malice aforethought constituted murder. Unjustified killing without malice aforethought constituted manslaughter. Behind all of this legal thought has been our traditional Judeo-Christian teachings. They are the bedrock on which our law ultimately rests. Men act freely, and they are responsible for the results of their actions. But to destroy his moral standing, nevertheless. Heretofore, our law in the area of reckless or negligent homicide has dealt with the conduct of private citizens, usually engaging in ordinary occupations, such as operating an auto on the highway, hunting with a dangerous weapon, providing medical treatment, and so on. Unusual cases have, of course, been brought before the courts that have involved operating a nightclub where numerous patrons die in a fire, playing Russian roulette, where players are held responsible for the death of another, participating in a drag race in which a death occurs. Analogies between these usual or exceptional cases and the evidence in these hearings are strange and uncomfortable, but also compelling. Can it legitimately be said that the FBI, like the nightclub owner, consciously risked or should have foreseen not a fire in a fire trap, but that others might be inflamed by its unlawful propaganda and do what the Bureau itself did not do, fire a deadly shot into Dr. King? Can it legitimately be said that the FBI, like the player of Russian roulette, consciously risked or should have foreseen not that one chamber of the revolver would be loaded, but that others might be encouraged by its unlawful participation in another kind of roulette, in which the stakes included Dr. King's life?